Are you going to give him a big build-up, a little intro, anything?
Yes.
Come on.
Also teaches with us at Harvard Law School, Trial Advocacy Workshop. Joe Tacopino was in the first week with us, although all of us were in different units. It's broken down into 6 groups, and we were all in different units of the first week, teaching young students how to try a case and how to ask a question, not to ask a question.
Was Joe? Was Lewin in there as a student or not? I guess he missed that class.
He's a former state's attorney for West Palm Beach County, or was it Palm Beach County?
Palm Beach County, right?
Palm Beach County.
Palm Beach County for many years. He looks like Dave. Dave looks like he's like 10, and he really is. He's got, he really is. He just doesn't age ever. He's got great experience. He's got great morals. He has great ethics, and now he has his own private law firm. So why don't you tell us about that first, and then we can go into your thoughts about today and the ethics of prosecution, given when I first called you, given that tape out there from Relli about needing a lawyer for a bag, or else it's called extortion.
Well, at first, it's great to be with you, Linda and Michael. I really enjoyed teaching with you, Linda. We were actually in the same section at
Harvard.
Right. And Joe Tacopina, who I had never met before, he's kind of a bull in a china shop. He was someone who, when I was involved with the Robert Kraft case, remember prosecuting that case?
That was your
he was representing Robert Kraft, and he went on TV and was just reading me the riot act. He was chewing me out, and I was like, who is this guy? And then I never met him until then. I went up to him. I said, hey, I hope you're not going to continue your broadside against me here. He's like, oh my gosh, I didn't know that was you. And we became instant friends. He's actually a really, really nice guy, a charming guy, and a really good trial lawyer. So I'm not surprised that it looks like he's winning here. Of course, you don't have to win by 51% to 49. You just have to get reasonable doubt. Get one juror and it's a hung jury. Get more than one. Get an entire jury with reasonable doubt and you win. And I think there's plenty of reasonable doubt here. I thought this case was weak to begin with. I mean, they never found the gun. They never found the bullets. The only one who found the bullet casings was the victim, who came later after the police were done searching the place. And although at the same time, I got to say the fact that the defendant says that he carries a starter gun with him, and that's what he was using. I don't know if I believe that, quite frankly.
Yeah, there was some confusion over prop gun, starter gun, and I don't know that I disagree with the theory that, hey, I've experienced some violent episodes of home invasion, and I want to scare people off. If you think it all the way through, as Linda and I have talked about, you may be asking for more trouble than you want, because brandishing a gun that won't stop somebody who might have a gun, that's a losing proposition. And that is, I think, that was reasonable to me, Dave. Tell me what you think. First of all, congratulations on you're going over to the dark side now. You've left the state. Oh, yeah. What's the name of the firm?
So my firm is Dave Aronberg Law, and we do civil and criminal litigation, some land use. And so, 561-765-5555. Also, I have a YouTube channel, Court Authorities. I'd love to have you guys on where we talk about law, politics, and true crime. But I love being on with you guys because you cut right to it. First off, I think there should be a rule in court, a local rule that says that you can't have a Lewin and a Levin in the courtroom at the same time. That should be a no-no. I mean, how confusing is that, right? I was just reading their names in the documents, like, oh man, is that Lewin or Levin? And this case is a mess. And I can say that now that I'm a former prosecutor. When I was a prosecutor, you have to tread gingerly when you talk about other prosecutors, but this case is a mess.
Yeah, I think you've got some latitude here. So I was about to ask a second question, which I kind of lost track of, but it had to do with the gun or lack of a gun. But let me go back to Relli, because he's really the central figure in this case, even though the jury may have sort of lost track of him at this point. How do you recover from a witness like that, who so clearly has lied on a number of levels, and he has been far from helpful in telling his own story, but very little time do we have a surviving victim, because we do mostly murder cases we have to follow. So here you have the guy, and he's a disaster. How do you recover from that if you're the prosecution?
I've had cases, and I'm thinking of one right now, the Travis Rudolph case. I know that you guys
I'm
covered
very familiar with that one.
Right. Well, There was a case where you have a likable NFL player who was essentially jumped at night. The group went to his house to do him some harm, and then he responded by going into his house, getting an AR-15 style weapon or an AK-47, a semi-automatic rifle, and then chasing them and shooting at them from behind 39 times. And in the car, as they're driving away, he keeps shooting and actually shoots and kills one of the guys. And we put him on trial. Travis Rudolph, we put him on trial. Said, you don't get 39 free shots. You can't run down the street when these people are trying to flee and shoot in a neighborhood and kill someone. You can't do that. And the jury heard testimony from Travis Rudolph, liked him. They heard testimony from the victims, the surviving victims. They didn't like them.
And the ex-girlfriend. They hated all the
people. Right. They didn't like any of them except for Travis Rudolph. So all it takes is for Relli not to be likable, which he's really not. I mean, or to give a story that people don't believe. I mean, one of the small details here is that he had this hand injury, and as Joe Tacopina said, waited to fly all the way across the country before seeking medical attention. And his response was, well, I had my hand wrapped that night, and I wanted to fly across the country because I don't trust LA. I didn't trust anyone in LA. Like, what? That doesn't make any sense. So that's just one of many.
By the way, thank you, LTOUXER became a YouTube member. We obviously appreciate everybody joining here tonight. Yeah, he didn't trust everybody, but I was more concerned as the ethics here and I wonder what would be the procedures in a DA's office this time of, the year we're in the year 2020. Well, this was taken earlier, 2022, 2023. You have somebody who's now on a tape. I don't know when they got the tape that says, look, I'm looking for 30 million. Then there's a second conversation. I'm looking for 30 million. And if I get it in cash, they'll never find me again. I'll be on some beach. They won't be able to prosecute without a victim. But I needed to get a lawyer because I needed to get the bag, meaning to extort the money. You usually carry in a bag when you're paying somebody off. I had to have a lawyer, or else it's called extortion. I think he spelled it. He said it wrong, extortion or something like that. But it was extortion. To me, that was clear. That's what came over. What's the ethics of prosecuting something like that? How do you choose to take the guy who says, "Hey, I'm going through legal extortion here"?
Well, the Lewin, not Levin, made a good point on cross that says that even if he was motivated by money to try to get as much money out of this rich rapper, A$AP Rocky, it didn't mean the event didn't happen. Both things can be true at the same time, that this actually happened, and yet the victim really wanted money. But when you're a prosecutor, you're very careful not to let yourself be used as leverage for a civil lawsuit. And that's why I tell people to this day, and when I was talking to people before, I said, if you wanted to do a civil lawsuit, if you want prosecutors and police to get involved, you might want to wait on that, because prosecutors and police don't like to be used. We don't want to be used as leverage. And here it looks like the prosecutor was used as leverage. And that's not a good look, even though ethically the prosecutor can pursue the case, because both things can be true at the same time.
Don't you have to give something maybe to an attorney general to evaluate? Doesn't somebody have to evaluate, though, whether or not they made a decision that this did happen? They made their decision it did happen, even with this tape. How do they make that decision or not give it to another office to at least evaluate it? Here, you decide whether this is extortion, and we'll decide whether we believe the witness, or is that not possible?
Well, when you're a prosecutor, you have to evaluate every case to make sure that you can get a conviction beyond a reasonable doubt in good faith. You have to believe you can get a conviction beyond a reasonable doubt. This is different than probable cause. So police, they can just arrest on probable cause, but prosecutors should not take the case unless you think you can get a conviction beyond a reasonable doubt. And if you have this stuff on tape, if you knew about that in advance, that's got to put doubt in your mind whether you can get that conviction, and thus you shouldn't move ahead with the case. So I don't know exactly how much they knew and what kind of evidence they were privy to, but they decided to file this case, and it doesn't look good for them at this point.
That's why, Dave, I say they never even talked to Relli ahead of time.
Right.
Regardless of the audio tapes, which are damning, Relli is damning. If you are the prosecutor and you're doing your due diligence, you're interviewing, if you spent 5 minutes with Relli, what would you think?
Yeah, well, it's like the victims in the Travis Rudolph case. sometimes you just do it because, well, should we allow someone to shoot 39 times in the back? And here, should we allow a high-profile man of privilege to shoot someone, even though the victim is unlikable and wants money? And so that's what prosecutors are thinking. They're convinced that there was a gunshot here. And, if you think about it, it probably was. I mean, but the fact that see what I said probably was, that's not good enough to get you beyond a reasonable doubt, right? That's reasonable doubt right there. Yeah. But I do think if you said what really happened, I do think there was an encounter. I do think there was a gunshot. I don't believe the starter pistol is shot in the air and everyone else was shooting. But do I believe that with beyond a reasonable doubt? No. And that's the problem in this case.
Hey, Linda, let me interrupt here just a second. I know you're poised with a very sharp question. And some of our chatters have asked about this Travis case too. So this is a shameless plug for both Dave and I. I did an episode for Taking the Stand, which was the Travis Rudolph case, and it's on the show Taking the Stand. It's on A&E. I'm sure you can find this episode. Dave was an expert on there from the prosecution standpoint, and it's a crazy case. This former NFL player, Dave laid out the details there. I won't tell you. Some of the finer points because it's worth watching. But Dave did a great job on it, defending the prosecution's point. And if you hear the story, like Dave suggests, here's a guy that takes an AR out of his house and shoots 39 times, including at a vehicle that's driving away from you. You're going to have something in your mind that may not play out in trial. And we see that in this case, too. If you hear just the raw facts about this case, this guy, Rocky, allegedly with a gun, perhaps a prop gun, perhaps a real gun, brandishes that weapon and then shoots at or in the direction of somebody, that's not proper conduct. That should be investigated and perhaps prosecuted. So I think both of those cases at the starting gate sounded like they could be legit.
Yeah, exactly. That's the point. And that's why it's not unethical for the prosecutor to pursue this case. They've got grounds, but you need to look at everything and the chance that your victim is really unlikable and has some holes in the story. There's a money motive, all that combined. And I think you're right, Michael. I'm not sure how much they knew of Relli, the victim in this case, before they decided to move forward with the prosecution.
But here you have the cops came to the scene right away, based on the 911 call, right?
18 minutes, but okay, we'll give them right away.
Well, right away, that no one picked up in the area where incident one, because Lewin kept trying to say incident one, incident two, and incident one was pretty far away from incident, not pretty far, but far away from incident one. They go exactly. They look around. There are no shells to be found. They're nowhere, and they conclude that there was nobody. There were no evidence that real gunshots had been fired, even though it could sound like it. And then no one, we get the shells several days later when Relli supposedly calls his lawyer. His lawyer says, you go back to the scene and you go collect the shells. So he goes back supposedly with his girlfriend, who doesn't testify now for the prosecution after they opened with her. The defense now says, after cross-examination, the prosecution may even say that Relli never went back to the scene. So if he never went back to the scene, there was no evidence of it. Where did he get the shells that he brings in? And thank you, Rice Street, by the way, for gifting 5 Justice Serve TV memberships. Where does he get the shells?
I don't know. And I didn't know that detail before, because I thought that he went back to the scene and he scoured it where the police missed it.
It's
and
questionable.
Found the shells.
Yeah,
so
it's questionable.
Right. So where did he get the shells if he didn't go back to the scene? That is a huge gap in the process.
Yeah, and we know that he went to a gun range after denying that he ever did, but he went to a gun range just prior to the incident. Could have pocketed some shells there, thinking, hey, someday I might need these. Or he may have had just random access to them. He found them, in theory, within an hour or so of the incident, turned them in the next day, or about, I don't even know if it was 12, 14 hours later. He had some time to get them. Yeah. Do you remember exactly when they were turned into the cops, Linda?
Yeah, he was 2 days, because the next day he says, I called my lawyer. First he says, I called my lawyer that night.
Like 3 a.m.
There's no call to the lawyer. So the next day he says, it wasn't that night. I called him the next day. He told me to go to the scene. So I go to the scene, and then he brings the shells back 2 days later, right?
Yeah, so he's had plenty of time to come up with some shells, And it would have been, if he had done a little investigation himself, he would have found out exactly what guns Rocky had in his possession, and he would have gotten shells to match that. Right. But that's a whole different problem.
Yeah, that's the problem, right?
It's a huge problem, and that's why I don't see this going to a conviction. I mean, can you imagine a unanimous jury finding beyond a reasonable doubt that ASAP Rocky did it? No, I cannot. I think at the best, a prosecution can get a hung jury here, but that's not good.
And we were talking about that, Linda. Remember, it's like normally if you're the defense, hung jury is, that's a victory. This is a weird case where hung jury may be as close as it gets to a win for the prosecution.
Right. And what do you do? You're going to try it again? Or
Yeah.
what do you do? I mean, that tape really bothers me, Dave. The tape really, really bothers me.
And it should. Also, what should bother you when the judge attacks the prosecutor saying, hey, stop yelling. And when you start admonishing the prosecutor in front of the jury, that is a terrible look. It's okay for the defense lawyers. In fact, if you're not getting admonished as a defense lawyer, you're not doing your job right. But as a prosecutor, that's a bad look.
That last little clip, Linda, that was in front of the jury where the judge reminds them of the 1054 issue. I'm sorry, 1074 issue. And says, I'm keeping track. The jury doesn't know exactly what that is, but it doesn't sound like he's, setting them up for an award of some sort. It sounds like it's a problem,
Yeah, and he said a couple of times, keeping track about the yelling or the stop it. It's become very loose, Dave, that all this is now happening in front of the jury. It started out very tight, and now it's becoming like, just get it over with,
Yeah, it really is. And the fighting with Relli and Tacopina, it takes a lot to make Joe Tacopina look sympathetic, but Relli did it somehow. He did it.
Okay, so let me ask you this serious question, Dave. As we look at the pending charges, assault, battery.
Michael has a question.
Oh, okay.
How can the prosecution demand a defense witness to be recalled when they already rested their case?
Well, did the prosecution demand that the defense witness testify? I'm not sure how that played out. Right. The prosecution could have a rebuttal witness.
Right. And I think that's what we're talking about.
Oh, okay. Yeah, that routinely would play out after the prosecution rests. And we'll see. We'll see if that actually happens. So, Dave, assault and battery. Can you find assault in the best set of circumstances here? We know that Rocky brandished something, prop gun, real gun. If that indeed was used to cause apprehension on the part of Mr. Relli, that could be enough, right?
Yes, but that's not exactly a capital crime. It's not a big deal. He'll probably get a slap on the wrist and go home if that's all they're going to convict him on. Assault, battery is different. Battery, you actually physically hit someone, shoot someone. I mean, that's just the least of his issues. If they find out that he shot him, he's going to get hit with more than that. But the assault, sure. I think the assault, when he gets in his face and starts yelling at him and brandishes a prop gun or whatever, that's the easy assault. But again, it's not necessarily going to be anything that incarcerates him at this point.
Here's another muddy part of this, Linda.
Yeah.
If Relli knew it was a prop gun, because there's some talk that everybody knew.
Right. Yeah.
Okay, well, then you can't really be apprehensive, right? Because it's a prop gun.
Well, also you have the crime of aggravated assault with a deadly weapon, which is serious. That's not a misdemeanor assault. That's a serious felony. Aggravated assault with a deadly weapon is a prop gun that the victim knows a prop gun, a deadly weapon.
I guess if you bash him over the head with it, but I think it's hard to feel apprehensive when he's like, dude, that's a toy.
And he's running after him. And I think that the point that he was running after them all the time. If he's scared of them and he thinks they have a real gun, why is he chasing them? Why is he chasing them down the street? After all this chaos. But let's see what some of our viewers think. And here's Wrestler's Mom. All the yelling is too chaotic. It has given me a massive headache. Lewin is petty. I'm not a fan. And I'm just following right down the list. Raynette. Some of Lewin's questioning seemed to go in favor of the defense. Survivor speaks. The case is crazy. Prosecutors.
So how do you really feel there, Survivor? Yeah.
And then there's also the view he didn't pull it out, it fell out, and Rocky was putting it away. I guess the question also is who was the aggressor? And that little tidbit in the tape, Dave, we started talking about this. I know you were on listening. Relli says to Wally that he pulled the gun out, whether it be prop or whatever, for self-defense. So he gives Rocky a self-defense argument in that tape.
I mean, the prosecutor must have been just cringing inside because as if things weren't bad enough. Now he's given Rocky an affirmative defense of self-defense. So yeah, this is it just keeps going downhill from here. You see the comments. If your viewers, your listeners are actually feeling this way about the prosecution, I mean, this is clear, at the very least reasonable doubt. If they don't like the prosecutor, then that's terrible. Normally you just don't like the defendant, right? But here they don't like the victim and they don't like the prosecutor. Bad.
Yeah. And I thought Joe Tacopino did, and I would say this to his face, a wonderful job. They're holding back. I thought he did what we teach at Harvard. Take those building blocks, right, David, and knock them down and rebuild your own wall with them. And I thought he actually showed great, shall we say,
restraint?
Restraint it's kind of restraint. I was looking for a different word, but he wasn't strident in how he went after Relli. He was restrained in how he, and kind of built back up to the point where you hated Relli. And then, of course, you have this crazy rule, talk to us, where the prosecutor who doesn't present the witness can object.
Have you seen that, Dave, what they did in this case? It was something they established from day one because Lewin wanted it. The judge was clear, and this happens in almost every case. I don't want 3 attorneys on a team objecting. One person will object. And normally it would be the person who did the direct of that witness would then object on the cross. No. Lewin said, is it all right, Judge, if a different person objects rather than the person that did the original examination? There won't be 2 of us, but there might be a different person objecting. Well, who's the objector? Lewin. So he's objecting to witnesses he did not directly examine. How do you like that?
Well, that's like the designated hitter rule, right? You know, you don't hit the field. You're just all you do is object. You're the objection expert. But I wouldn't want that as a prosecutor because you study your own witness and the witness you're going to cross, and that's the one you know everything about. You're ready to object. You're listening to every word. Why would you do that for witnesses you don't call? That's not your witness. You have people to help you. Why would you do that? That doesn't make any sense. It makes it much harder for you. Raises the level of difficulty. So I don't agree with that. It's
so arrogant, I think, and it also it cuts Paulie P's testicles off. Paulie P's supposed to be the lead attorney. Just not literally. He's supposed to be the lead attorney, and Lewin parachutes in. He's second chair, but clearly he's calling the shots. And to take that step just undermines his own his own teammate.
Well, Lewin could have come in and said, "You know who I am." You ever heard of Robert Durst? Ever heard of Durst? Yeah. Okay, so you're supposed to be first chair, but I'm doing the objections, okay? And you're getting the coffee. So, yeah.
poor Paulie P, who we like. We like Paulie P.
Yeah, no, we thought that he did he was very normal. Not normal.
Yes. Yeah. Earnest, straightforward.
Right. Yeah. At least he was trying to say, I'm going to give this to you. I'm not taking a side. I'm giving it to you. I got on this morning and I had to go to a meeting, and then I got on and I heard John Lewin again. And I know he's a very good prosecutor. I know he's very committed. I know he believes what he's doing. But this constant objected, and when the witness would say no and try to explain what he meant by no, or maybe he would, move to strike. And I don't think juries want to hear what the witness is saying. Not every question is a move to strike.
That's a great point. That's something that really should be taught in trial advocacy, because although he's right, technically, the witness needs to just stop. But it makes you look bad in front of the jury when, here's the jury that wants to hear this. And you're like, not only do you say strike, but you do it in a very loud way that gets you admonished from the court. It makes you look unsympathetic in front of the jury.
Very unsympathetic in front of the jury and all the people watching, right?
Yeah. Unlikable. Likability matters. It matters in politics. It matters in court.
Someone once said, never underestimate the power of likability. Somebody once said that.
You know what they say? The most important thing is authenticity. And if you can fake that, you got it made.
See what you did there?
Thank you, Michael. Thank you. Linda was ready to move on. But thank you.
You're ready to move on, but I'm just pull back right now. I didn't pull it back. Raynette said that she felt that Lewin was trying, and I think she meant Lewin was attempting to try to hide something every time he did this kind of move to strike. And I'll couple that with this comment again from Wrestler's Mom. And these are chatters who've been following this case. If Lewin played less of a role in the prosecution team, they may have this in the bag. And she doesn't mean the extortion bag. Thoughts.
That's a bad sign. Yeah. What do you think of that, Dave?
Well, it's bad when all of your comments are negative to the prosecution. That hurts me as a former prosecutor. We like to be on the, wearing the white hat, the good guys. And when you're losing the Baden and Bryant audience, that's bad.
Yeah. Right? And that's something that we've been talking about, because it just seems like we've seen a string of these cases in which the prosecution was a little shaky. And they've resulted in defense decisions in one way or another. I don't know. We don't know if it's a sea change or if it's just coincidence that some of the high-profile cases have ended up this way, from YSL to this current trial in Florida, the Ty Tucker case. I don't know. What are your thoughts on that? Is there some sort of swing that prosecution teams are getting, I don't know, more desperate to bring about a case that may not warrant it?
No, I think that these are just high profile cases. I've seen conviction rates pretty steady where I am. So I saw you're using a couple of cases as good examples, but generally these cases end up in guilty verdicts because most of the people who go on trial as criminal defendants are guilty. Wouldn't that be terrible if most of them are innocent? That would be a massive fail in the system. So, in fact, I'd say an overwhelming number are guilty, and that's me now on the other side. But
yeah,
the ones I represent, they're all squeaky clean, innocent. But but most of the people on trial are.
But they may not be guilty of the crime for which the prosecution charged. I always make that distinction to people. Look, people can get charged with murder. Maybe it's manslaughter. Yeah, you know what I mean?
True.
Maybe it's so that it's not just always so clear, black and white. You're doing a job because maybe there's an overcharge, and we've seen overcharges. I'm sure you've seen other offices overcharged, right?
Yes. In fact, I have, in retrospect, on some of the cases that we've lost, we've said, hey, maybe we overcharge. Sometimes the problem is in the statute also.
Right.
So the person did it. And when I say they're guilty, it doesn't necessarily, you're right, mean that they're guilty of this specific statute. We know this person did something wrong, and we know this person shot and committed an assault, but can we prove that this was a real gun and not a prop gun? And there's certain issues. Then you have the Alec Baldwin situation, not to bring up another case where, you had the whole case thrown out because of prosecutorial misconduct. That's a whole nother level. So,
and that we've seen. And then the Karen Reed case, of course, is ongoing ball of mess, prosecutorial issues there too. I know you would never do this, but sometimes it seems like overcharging is used as a weapon, so that the defendant will cave into something lesser, whether guilty of it or not.
I've come on your shows in the past and talked about the danger of overcharging. You lose credibility in front of the jury. I would rather get what you can get and not try to go for the home run when the home run is not available because you're playing in a cavernous ballpark. So I'm with you. Be careful not to overcharge.
Okay, here's a good question. Can Rocky still get an assault charge, convicted, I guess, of an assault charge, if Relli was the aggressor?
It depends. So the whole thing of self-defense means if Relli retreats. So if Relli's the initial aggressor and then retreats, then Rocky cannot go and be the initial aggressor. You don't get like a get out of jail free card. Once someone's the initial aggressor, after they retreat and turn away, you get to go chase them down and shoot 39 times from behind. Or, well, I guess in one case you're allowed to do that, but
in California, it's a little more liberal than that. They if there is a true self-defense that's legit, you can actually pursue until the threat is neutralized, whatever that means. It's pretty aggressive in California.
Well, if the person retreats, right? If the person retreats and ends the threat, you're limited as to what you can do. I use the Travis Rudolph example again, where you just can't, even in California, chase someone down the street who did threaten you after that person has turned tail and left and tried to run away and end the threat.
Well, that's just it. It has to be some reasonable perception that the threat exists, continues, even if they're running away from you. Like maybe they're running away and shooting over their shoulder, whatever the scenario might be. Yeah. But as long as it's reasonable for the person pursuing to think they still have something to defend against, then they can neutralize that person. It's pretty aggressive. Didn't get there in this case, but I saw a question that came and went. I think it's Ashley. Let me see if I can get that up here. Ashley, when do you use an affirmative defense? And then referencing Travis Rudolph again, he used self-defense. And we're starting to learn, Linda, that even though it wasn't really part of the story of the defense, that affirmative defense may come into play now, right?
Right, because it was because Relli said it. Relli said he pulled the gun out in self-defense, meaning that he was the aggressor, and Rocky was trying to defend himself. So whether it be a prop gun or a regular gun, but I don't see the other thing. I think there's a problem. I don't see those. Remember he hit the wall or the person 3 times. Relli did. That's the testimony, and that looks to me like. Dave,
that's how it might happen. Yeah.
Have you boxed or whatever?
I've done kickboxing.
Okay.
But not like the real stuff, MMA or anything. I'm talking about in the gym, in a controlled environment. So no, there were no major injuries.
Yeah. No bar fights, nothing like that.
Not yet.
That's not a graze. The bullet just happened to go. Let me just graze 3 perfect knuckles. Around, and it looked like it was from a hit. That's what it looked like. I mean, I'm sure the jury, and there's no medical testimony addressing it. And it's interesting because the testimony is that Relli went to Metropolitan Hospital in New York when he got back, but no one from Metropolitan Hospital was coming in. There's no records coming in. That's
because the injury is a joke. I mean, I'm not saying it couldn't have happened, Dave. I mean, a lot's going on. Things are moving. Who knows? Maybe a president-to-be is going to get nicked in the ear. Who knows what's going to happen when a bullet's fired and all of these actions are taking place? So maybe that is how it happened. Maybe.
But there's no medical evidence to come say it. No one. Metropolitan's here in New York. We get a lot of gunshots in New York. Usually, the Bellevue is the place, obviously, they get treated. But don't you think that Joe's going to say when he closes? Did you hear anybody?
There's no proof. Yeah.
Come and say this was he wanted to get treated. This is a bullet wound. And by the way, thank you, Rice Street, again for gifting 5 more Justice Serve TV memberships. So I think if I'm the defense, I'm going to finish up with another witness that shows Relli as a liar. And there was one area, obviously, there was a number of areas, but remember, and I only say this because I just ordered my.
Oh gosh, here we go.
Here we go. I mean, I'm color coordinated today with orange, but
it's a double shot of extra caffeine.
Dunkin' Donuts, my mango green tea, the cartridges, and I don't know if we saw the envelope, but remember he said the cartridges. Relli said the cartridges he picked up, he bought into the police in a bag. Dunkin' Donuts, and now I just got my Dunkin' Donuts order, and they delivered it in a white bag. If you get like the egg wraps or something, it comes in like a
the brown, recycled bag kind of color.
Recycled bag. And I don't know, did we see a picture of the bag that he brought them in? Because I'd want to track down everyone that can show that if I were doing this, that
you bring a Dunkin' rep in.
I bring a Dunkin'.
Yeah.
I bring a Dunkin' wrap in, right? Here's to my Dunkin' every single day. I have it, right? Yes, I bring. And by the way, along with that, the hospital. I mean, the hospital. He didn't go to. He was 2 days. 2 days later. 3 days later.
But he had it wrapped up, Linda. He had it wrapped up. Sorry, I can't do that with a straight face. That's what he said. He said he had it wrapped up.
Maybe with a Dunkin' wrap bag.
He had it.
Yeah,
he had it wrapped up, flew across the country, and he met with his lawyer, and then he went to a hospital because he doesn't trust hospitals in Los Angeles.
Right.
Well, yeah, they're not very good at treating gunshot wounds, right? Because they don't see very many of them.
And that's just near a high school in Los Angeles.
Just bad.
Yeah.
So I'd want to. I mean, I think the prosecution ended the cross-examination of Lou Levin on a whimper today. I thought Lou Levin did a wonderful job for him. He looked like he was trying to answer the questions if he wasn't getting objected to by the person doing the cross-examination all the time when he was trying to say no, yes, explain what happened. And if I'm the defense, Levin was great. We don't need to bring anyone back from New York, but I want to reinforce him. I'd pick out one spot, maybe 2 spots, but we only know it's one witness. One spot where you could show that possibly Relli lied and bring that witness that lied and then rest. I mean, that's would be my game plan.
Okay, I'm calling a late witness from Dunkin'. I'm calling a Dunkin' expert.
If there's a Dunkin'. Oh, yes. Oh, what is that? A delivery checkout bag?
Yeah, it's some sort of black Dunkin's bag.
Where'd that come from? Because
from my phone. I don't know.
Your
It
phone.
says Munchkin Run, so it's a little some sort of delivery bag or maybe a big.
Well, let's see. Let's see what happens. I don't
So
know.
what do you think of that?
Caught
Aha!
here on the East Coast. We have DoorDash and we have Dunkin' Runs the Dunkin' Run queen. Okay.
Just trying to plant some, seeds of doubt. Who knows? Who knows?
Oh my goodness gracious. So there we go. I don't know. How about you, Dave? How would you try to end it if you're in the defense?
I like ending it on all the inconsistencies in Relli's story. Relli wasn't likable on the stand. Focus on him. Yep. Don't put the focus on ASAP Rocky. Put the focus on the guy they didn't like and show how much of a liar he is. And really all it takes is one lie, and that should be reasonable doubt for this jury. But if you can show 10 lies, that's it. Then I think Tacopina is going to win this case.
That'd be really interesting. And really, by the way, I think he's been a very good client in the courthouse there in the trial. There was some issue with this AUG about whether or not he was telling 12E not to answer, but I think he just kind of blurted out,
Well, yeah, because that's it's a Fight Club ripoff, and
right.
Probably a little inside joke between them, right? And I think he might have been signaling kind of like wink, wink. That's the joke for AUG. And that's kind of what was repeated on the stand. At the close, I would do, as I've said before, play the testimony about I definitely didn't go to the range, and then bang, bang, he's at the range. You mix that up with your phone call and the reference to the extortion LKB, and
And Johnny Logan to the front desk sergeant said he bought the cartridge in a black plastic bag.
Oh, plastic. That one was not. I don't think it was plastic. That's going to take further research.
That's not plastic coming there. I think California's a little woke when it comes to.
You think?
New Jersey and New York, we don't use like plastic anymore. As a matter of fact, in New Jersey, we don't even use bags. You can't give a bag.
Yeah, it's funny. That was all happening, and then COVID hit, and all of those rules kind of went out the door. And now, of course, I hear we're getting plastic straws back. So
yeah, you're getting plastic straws back. Although Dunkin' never, I have to dive them out. They never got rid of the plastic straws. They
good
always
for them.
Plastic straw.
Those are like oversized plastic straws, even.
Yeah, they always had a plastic straw. Everybody else here in the city was setting the paper straws, but the Dunkin' never wavered, because the rule was that you could use the stash you already have. And so I assume that Dunkin' worldwide had like millions of plastic.
And who's gonna try and enforce that? Dave, as the former state attorney for Florida, did you do any straw checks when you were out and about? Make sure people didn't have plastic straws?
That's the last thing I was going to do was to shoot our violent crime task force and go after plastic straw. But hey, at least now we're in a free society where you don't have to worry about the plastic straws or the environment or the price of eggs, right? Because
What is? I don't understand the whole egg thing. I don't understand. Yeah,
that's a whole other show. That we'll do on your show. We'll
do on Court Authorities. We do talk about those types of things.
Okay.
All right, we'll do that on your show.
Yeah.
So, any of our viewers, because we have 354 still watching, not just viewers. We have a lot more viewers watching, but chatters. This case is really taken over. Anyone have a final question to ask Dave before we say goodnight to you and see you tomorrow at lunchtime, because we're going to be back.
Do it again. Yeah, I think somebody just asked for your phone number again, Dave.
Sure, 561-765-5555. Because we're a new firm, the website goes live any day now, and so in the meantime, it may be tough to find us. So save that number, or just find me online. Easy to find. And thank you for having me on, Linda, Michael. You guys are awesome. Love your show.
Thank you,
man. Always appreciate it, Dave.
All right.
See
you next time, bud.
Take care. See you next time.
All right. I know it's time to run, so we shall. Tomorrow they're starting at 10 again, which is 1 o'clock for us. Then we'll. Could be very interesting day. Did you say they're leaving early tomorrow? One of the jurors have something.
One of the jurors said something that they have to.
3 o'clock.
One of the jurors, unless it was somebody who's a court officer, but I assume it was one of the jurors, said they have to be somewhere at 6 o'clock, and the judge asked if it could be pushed back, and she said no, and I think it was a she said no because she was had to give a lecture, so they're leaving early. So. Then it looks like if that happens, then it looks like summations is going to start Thursday. 3 3 summations and a charge. Oh, I'm so sorry.
There you go. Get the hell out of here. That's what that's telling you. So we'll do that tomorrow. Yeah, at some point.
We will see you all tomorrow. Thank you. You can stay on the channel here and chat. Missy's gonna. Are you gonna run anything or run anything?
You're just driving Missy into the ground, just working her to death.
Wait, we shout out to Missy and Dizzy. They just are fabulous and just wonderful, and know that you love this. You love chatting. You love your community that you're building, and we love the community building. And we will see you tomorrow at the lunchtime hour. Although
that's right.
Streaming from 10 o'clock California time, 1 p.m.
Yeah, and if something happens, before the normal break, who knows? We'll jump on and chat. Okay, well, until then, try to do the right thing. I'm Michael Bryant, and you are
Linda Kenny Baden. Together, we are Justice Served TV. And if you like us, please subscribe, share, hit the like button, and you'll get that notify rings.
I just cut her off. She never likes that.